Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Today's question comes out of our legal hotline mailbag. The question is, I am currently on the buyer side of a transaction that terminated a few weeks ago. And since termination, we have been battling the seller to get our earnest money back from the title company. The seller party has now not been responding to our emails, and my clients are prepared to fight for the earnest money. I have never experienced this before or gone to interpleader, so I feel lost trying to guide my clients through the process. Is this something that the legal hotline can help me better understand? And the answer is yes, I can help you better understand this. It sounds really like the best understanding this broker needs is that this broker's buyer client should be advised to seek legal counsel. There's now a contractual dispute, it appears, as to who is entitled to ownership of the earnest money. There may be a simpler solution, and we're going to get to that at the very end, but I want to try and at least give you some guidance on what the interpleader process looks like so that you understand why, if the parties are headed to interpleader, it's not something you can help them with. It is a pure act of the practice of law to give counsel to a buyer or seller who's engaged in the interpleader process. Why? Because if an interpleader action is filed, it is a lawsuit. The escrow company that's holding the earnest money, or whoever is holding the earnest money, takes the earnest money and gives it to the superior court. And what the escrow company says to the superior court is, Superior Court, here's a chunk of money. As the escrow company, we have no idea whose money this is. It could be the buyers, it could be the sellers, it could be anybody's, but we think it's either the buyers or the sellers. And so because of that, we are naming both the buyer and the seller as a defendant in this lawsuit. So the way the caption to the lawsuit reads is that the escrow company is the plaintiff and the buyer and the seller are both defendants in this lawsuit. Both buyer and seller must now appear in the lawsuit and defend their position, claiming ownership of the earnest money. You are in a lawsuit at the superior court. The escrow company is going to extract themselves effectively from the lawsuit by saying, all we know for sure is it's not ours. And so the court's now not going to need to know what the escrow company's position is really beyond that. The lawsuit is between buyer and seller. Except that the escrow company retains the statutory right, the contractual right to recover the escrow company's attorney fees and court filing fees associated with initiating that interpleader action. So let's say that the interpleader is over an earnest money of $3,000. Of that $3,000, the escrow company is going to be entitled to recover, more likely than not, entitled to recover the attorney fees they spent in starting that lawsuit, along with the court's filing fee. Suffice to say, there may not be nearly as much of that $3,000 earnest money left as the buyers thought they were fighting over. So let's say that the action then proceeds. The parties again have to appear and they have to defend. If either of them fails to appear or defend, then the other party may win by default. But if there is litigation, if there's a battle in court over who's entitled to the earnest money, then the court's going to make a substantive decision based on what the court hears as the facts and the arguments of law and conclude who between the two parties is entitled to the earnest money. It is very likely, although I can make no guarantees, it is very likely that the court will award the prevailing party the entirety of the earnest money. So let's just pick a party. Let's say seller wins this battle. And let's say the earnest money is $3,000. And let's say that $2,000 of that $3,000 is being awarded to the escrow company as repayment of their attorney fees and their filing fee at the court. So $2,000 is paid out of this chunk of the earnest money before it ever leaves the court's registry. $2,000 is paid to the escrow company. So now we've got a $1,000 balance. The court's judgment is likely to say that if the seller is the prevailing party, then buyer, you owe seller $3,000, even though there's only $1,000 left in the court's registry. You're going to have to make up what was paid to the escrow company. And, again, no promises, but it's entirely likely that the court's going to say, in addition to that $3,000, buyer, you also have to pay the seller's attorney fees and costs, whatever that amount may be. That's how an interpleader process works. At the end of the interpleader process, the escrow company is gone, probably with recovery of what they spent to get there in the first place. And either buyer or seller, sometimes a baby gets split, but either buyer or seller is likely to be awarded recovery of the earnest money plus fees plus costs. The losing party is likely to have a much bigger debt in this scenario than had they let the earnest money go in the first place. That's a kind of a general explanation of the interpleader process. Perhaps a simpler answer in this particular fact pattern where the parties are disputing and the seller has gone silent. Remember, that was part of these facts, was that now they're not hearing anything from the seller. Buyer has been making demand for the earnest money. There is a statute, a Washington law, intended to provide a solution in this scenario. It is RCW 64.04.220. 64.04.220. It was enacted by the legislature at the urging of the industry several years ago. And when I say the industry, the way this statute came to be is that the Department of Licensing convened a work group that included escrow, Northwest MLS, Washington REALTORS, broker members, consumer representatives, all with an effort to find a solution to these captive earnest money scenarios. And this statute says that if either party makes demand on the holder of the earnest money, so if they send a demand to the escrow company saying, release the earnest money to me, the statute requires the holder of the earnest money to notify the party on the other side of the transaction that a demand has been made. If there is no response from the other party, then escrow, after the passage of the right number of days, and the number of days are established in the law, after the passage of those numbers of days, the escrow company is required to take the earnest money and give it to the original demanding party if there's no objection to that from the responsive party. Meaning that in a scenario where the seller has just gone absent, they've quit responding at all, maybe, buyer broker, maybe your buyer recovers the earnest money by making that written demand on escrow consistent with this Washington law, triggering the escrow company's response to receipt of that written demand, delivering that response to the seller who remains absent, resulting in a scenario where escrow is then required after the passage of days to give the earnest money to your buyer client without a lawsuit. Understand, however, that the initiation of that process could result in the escrow company being forced to file an interpleader action. So if an interpleader action is not what your client wants, then your client needs to be careful about triggering that statute. In any event, whether your client is considering triggering that statutory protection or already faced with an interpleader action, your client needs legal counsel. Nothing about anything we've discussed in this video has anything to do with the provision of real estate brokerage services. And in every case where this question is the issue you're facing, you should advise your client, buyer or seller, to seek legal counsel. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.